Starting on January 1st, job seekers on the West Coast will know a bit more about open positions before they apply. Both California and Washington State are requiring employers to disclose wage scale or salary ranges for all posted job openings. This new rule applies to employers with 15 or more employees. These transparency laws are aimed at alleviating sex-based wage disparities. Now, California is going to go even further. By May 10th of next year, employers with 100 employees or more will have to submit pay data reports to the state's Civil Rights Department. These reports must be broken down by race, ethnicity, and sex, and must be reported every year. 7 states and New York City now have pay transparency laws. Now, while they're all very similar, they're not identical. If you hire in more than one state, you need to be aware that a one-size-fits-all policy may not be the best solution. New York's pay transparency law is still in its infancy, but concerns are being raised that employers are listing incredibly wide ranges for some positions that do little to help applicants. The law requires that employers make a good faith effort to list the minimum and maximum pay in job listings, but New Yorkers say they're seeing many postings with six-figure differences between the high and low rates. For example, one job listing for a news editor says the job pays between $50,000 and $180,000. The New York City Commission on Human Rights says this is happening because the law requires the disclosure to be made, but offers no guidance on how wide or how narrow the range should be in order to comply. Some employment experts say applicants are more likely to trust employers that either offer a narrower range or clearly explain why listings have significant differences. While salary transparency might help job seekers, those in California might find their start date delayed because a new law passed by the legislature that would have required access to basic information like dates of birth has been vetoed. For the last year and a half, we've been following the fallout over the case of All of Us or None v. Hamrick. In this case, a civil rights organization for formerly and currently incarcerated individuals sued to prevent state courts from allowing information like dates of birth and driver's license numbers to be used to confirm criminal history records. Plaintiffs claimed this information should not be available in order to protect their privacy, and an appeals court agreed. Unfortunately, blocking this information caused serious delays for background checks. A coalition of agencies concerned about losing access to these identifiers lobbied lawmakers, arguing that this change not only made it harder for people to get hired, but it also made workplaces less safe. Lawmakers agreed, and they overwhelmingly passed legislation to fix the problem. Then, Governor Gavin Newsom vetoed the bill. There is no word yet on what the coalition will do next, but for now, employers can expect to see delays in background screening in California. And that wraps up our final update for 2022. We wish you all happy holidays and can't wait to see you again in the new year. In the meantime, if you'd like to learn more about building the best background screening program for your business, check out sterlingcheck.com.